Welcome to Go News, where we bring you relevant and important information. I'm sure Michael with Guns Out TV. Before we get started, we want to do a little homework first. Please make sure you like the video, share it with as many people as possible to defeat YouTube's algorithm, and comment below this video to let us know what you think, as we love reading your comments. We love engaging with you all. The only thing that we ask, because not everyone agrees on everything, and that is okay, is that you're always respectful of each other. So on September 7th of this year, the National Foundation for Gun Rights filed 5 new lawsuits in 4 federal circuit courts to challenge magazine and gun bans in the following states: Massachusetts, Connecticut, Highland Park and Naperville, Illinois, Hawaii, and Colorado. Now, these are all important because each of those circuit courts have jurisdiction over a plethora of other states. For an example, the first state I mentioned, Massachusetts, if they win that case, a victory there would establish legal precedent throughout the entire circuit, including Maine, New Hampshire, and Rhode Island. The same applies for the second state, Connecticut. If they win that case, that would have precedent in New York and Vermont, and I can almost guarantee you that the people in New York are probably like, wait a minute here, let us figure out what we already have going on. And by that I mean the most recent Supreme Court case, which that decision was written by Supreme Court Justice Clarence Thomas. Highland Park, Illinois, which is in the 7th Circuit Court of Appeals, that will set a precedent for Wisconsin and Indiana. And Naperville, Illinois, and that case has been interesting. So in Naperville, which is a city, the organization is filing a lawsuit on behalf of Robert Bevies. Now, Robert is a local gun owner who stepped up to challenge a local ban by his local city council. He clearly lost. So the National Foundation for Gun Rights is arguing that this new local ban is in violation of Heller. This is also in the 7th Circuit. Hawaii, which is in the 9th Circuit, would also set legal precedent for a whole bunch of states, guys. So check this out: Alaska, Washington, Oregon, California, Arizona, Nevada, Indiana, and Montana. So that's what I was talking about. If they win any of these cases, because each of those U.S. circuit courts have jurisdiction over a plethora of other states, the precedent would send reverberations across a significant portion of the country. And finally, Colorado, which is in the 10th Circuit and is the 5th state and their most recent suit. So the National Foundation for Gun Rights argues that Colorado is in violation of the 2nd and 14th Amendments, and they're also suing the cities of Superior, Louisville, Boulder, and Boulder County to overturn similar laws at the local level that deal with possession, sale, and the transfer of what has been deemed by those municipalities as assault weapons. Again, this will set legal precedent in several states: Wyoming, Utah, New Mexico, Oklahoma, and Nebraska. So combined, all of these lawsuits represent nearly half of the country. So I can guarantee you both Republicans and Democrats are more than likely watching these cases to figure out what's going to happen down the line in the next couple of months, in the years to come. With the decision handed down and brewing, laws like these will now need to find their justification in the history, text, and tradition of the Second Amendment. And that's an important distinction to highlight here, because what's most important about the brewing decision from the Supreme Court that occurred a few months ago, the means end test, which is an analytical process involving examination by many courts across the country. Essentially, the intermediate scrutiny and strict scrutiny can't be used to hold gun laws in place under the guise of state interest or public safety. Now, you're probably wondering, sure, Michael, what does that mean? That sounds absolutely complicated. And guys, it is a little complex a little bit. But what it basically means is that a state must justify their new gun laws or existing gun laws based on history, text, and the tradition of the Second Amendment. So no longer, guys, can a state say that we're using or enacting these laws or maintaining these laws under the guise of state interest or public safety. The brewing case, again, which Justice Clarence Thomas wrote the lead decision on, said, nope, no more. That changes everything. So this is an interesting history, because I'm wondering how many of these states will argue this. As many of you know, there's a complicated history in this country with gun rights and people of color. More often than not, many states just merely 40, 50 years ago had some pretty draconian gun laws really aimed and targeted at African Americans for reasons that most of us are likely already aware of. So I believe we'll likely see more of these lawsuits challenging gun bans in the coming months and years to come. Thanks for watching, guys, and make sure you like, comment, and share this video. I'm Michael with Guns Out TV, and this is another episode of Go News.